body corporate into two categories. The first category is where the body corporate is providing services under a direct contractual relationship with the provider. I'll refer to this category as data controller. And the second category is where the body corporate is providing services either to the provider of information or to the data controller pursuant to a contractual relationship with the data controller. Refer to this category as data processor. Provider is defined as a natural person who provides sensitive data to body corporate. Therefore, there are two categories. Category one is where the body corporate is providing services to the provider under a direct contractual relationship with the provider. The second category is where the body corporate could be providing services either to the provider of information or to the data controller under a contractual relationship with the data controller. The classification presupposes that the data processor is in all cases acting on behalf of or under the instructions of the data controller, while perhaps this could be true in most cases such as call centers and the business process outsourcing centers such as the centers that process loan, mortgage transactions, medical transcription centers, but it does not consider a situation where the data processor may not act under the data processor receiving the personal information may not be acting under the instructions or on behalf of the data controller. I have an example for this. A bank that has a bank may share the personal or financial information of its customers with a credit agency or a credit card company. The credit agency and the credit card company may access this data for a different purpose. They may not be, they may process it independently of the data controller, but they may also not be providing any services to the data processor, or they may also not be acting under the instructions or on behalf of the data controller. Under the data privacy rules, data controller has higher set of obligations than that which is applicable to the data processor. Data controller is required to comply with all the provisions of the data privacy rules, whereas the data processor is exempt from complying with certain key conditions such as consent, collection, and disclosure requirements, and also the access request. All other obligations such as publication of privacy policy, transfer conditions, and implementation of security controls apply to the data processor. It's understandable that data processor is exempt from the consent requirements since it is the data controller that is in direct contractual relationship with the provider, and in the outsourcing context, the data controller would have obtained these consents, that is a foreign body corporate, from the provider of information. However, it's unclear why the data processor is exempt from certain key obligations such as prohibitions on processing the sensitive data for purpose other than the original or defined purpose, or providing access rights to the provider of information. Also appointment of grievance officer to address grievances of the provider, and also the disclosure conditions. Originally, prior to the clarifications by the government in August 2011, the data privacy rules applied equally to both the data controller and the data processor. The Indian outsourced providers performing solely the processing functions, such as the call centers, the data centers and the business process outsourcing centers, such as those medical transcription or mortgage processing centers, acting on behalf of the foreign organization and with no access to the provider of information, that's a foreign individual, were also required to comply with the consent requirements. The Indian organizations found it.
This is going to be done especially in relation to the EU and the United States. Mr. Dayavacharya is again moderating this session, which is really good. And the session is going to be really special because we have Ms. Nadezhda Purtova, who is from Sweden and is joining us through a video conferencing. So we are going to first show you, she sent us a recording of her presentations which we are going to play. And there are some connectivity issues right now, so we're going to let you know she's going to be available online with us for Q&A. I can also talk about data protection has offended the internet a bit. So we have the student speaker also for this session. As I mentioned that this conference is also promoting research by students in law and technology. So I hand over the session to Mr. Acharya. Thank you.
This afternoon we'll be looking at a comparative analysis of data protection frameworks and asking ourselves where India stands in this process. I understand we'll be looking at India and India's compliance with the laws of the European Union Commission and also our relation to the US Safe Harbor Principle. Now before we go further, Raghunath, Ananthapur was supposed to be moderating the session and he had to leave unfortunately. So I've stepped into his shoes. I will restrict myself to just introducing the panelists and at the end moderating questions if any. We are joined by Ms. Nadezhda Purtova, who is a postdoctoral scholar at the Tilburg Institute for Law, Technology and Society in the Netherlands. She was an associate editor for the track on personal data markets for the European Conference on Information Systems, which is the premier annual information systems event in Europe. She focuses, her primary field of expertise is European data protection law and the interaction of law and technology. She researches the scope of property rights and personal data with a view to develop a system of personal data licenses facilitating privacy-friendly data flow. And in 2011, she received the Tilburg Best Doctoral Dissertation Award for her dissertation on property rights and personal data from a European perspective. This panel also has Ms. Rakhi Jindal. The other three panelists will join us after the video conference. I think it's just a question of getting a better view. Ms. Jindal is a senior associate of the Technology, Media and Telecom, the TMT practice group at Mr. Desai Associates in Bombay. She focuses on cross-border transactions in the telecom and technology industries, and she advises clients on extensively on data security matters. She is well published and well researched. She will join us, she's in the front row, she will join us shortly. We also have Prashant Iyengar, who is an assistant professor and the assistant director of the Center for Intellectual Property Rights Studies. Prashant graduated from NALSA in Hyderabad and the Columbia Law School. And he worked with Privacy India with the Center for Internet Society, and he was a researcher with the Alternative Law Forum. He has also been guest faculty at a number of institutions, including Christ College, Bangalore. And we are also joined, that's it. So we have these three panelists. So perhaps to begin, we can have so to begin, we'll have a video, and I understand it's a recording. It's a recording, right? Yeah, so I understand it's a recording of Nadezhda's presentation. So let's start that first.
Good afternoon, ladies and gentlemen. My name is Nadezhda Purtova, and I represent Tilburg Institute for Law, Technology and Society and the University of Groningen, the Netherlands. First of all, let me thank the organizer. Gentlemen, my name is Nadezhda Purtova, and I represent Tilburg Institute for Law, Technology and Society and the University of Groningen, the Netherlands. First of all, let me thank the organizer of the conference for inviting me to give this presentation. In my presentation, I would like to avoid a standard introduction into the European data protection law. Instead, I would like to focus on some of the shifts in the European concept of data protection. The European data protection law is often considered a superior standard, a beacon that other jurisdictions should follow. But in 2013, as the data protection reform picks up speed, Europe finds itself reconsidering those standards and shifting priorities. The shift that goes to the very core of the data protection regime is the change in the rationale of the data protection measures and who has the default entitlement in personal data. I will argue that despite the rhetoric of individual control, the proposal for general data protection regulation shifts the core of the European data protection from informational self-determination based on consent to the default entitlement of the information industry to process data. I will also show how this shift may affect India via European regulation of transborder data transfers. Let us first examine the default entitlements in personal data under the current General Data Protection Directive. As any data protection instrument, the directive is a product of legislative balancing between the informational self-determination and control on one hand and the interests of others to process data. The result of balancing is the principles of data protection: fair and lawful processing, data minimality, purpose limitation, information quality, data subject control, and data security. Data subject consent is only one out of 6 grounds of lawful data processing. Data processing is also lawful when it is necessary for performance of a contract to which the data subject is a party, or compliance with the legal obligation of the controller, or performance of a task carried out in the public interest, or for the legitimate interest of the controller, unless it is overweighted by the privacy interests of the data subject. But national legislation of some member states, for instance Germany, interprets Article 7 to mean that data processing is lawful where there is a data subject consent, including given in the contract, or where processing is prescribed by law. The commentators from the academia also argue that the consent rule should be applied by default due to the normative rules of data protection and privacy. In particular, Article 8 jurisprudence of the European Court of Human Rights recognizes self-determination as protected under the Article 8 right to privacy. All this supports the conclusion that the General Directive gives normative precedence to the consent rule, and that the data subject should have a default entitlement to shield his data from being collected or further processed. In other words, the basic principles of the European data protection under the current legislation are non-processing by default, or data processing with consent or where the law applies, or where the law prescribes. Multiple expert evaluations of the directive called for better enforcement of the substantive data protection rules, but did not reveal the need to reconsider any of the substantive principles of the directive, including the conditions for lawful processing. Nevertheless, the European Commission, in the draft regulation, chose to move away from the informational self-determination towards information industry's entitlements to process data as a default. This choice is evident from several changes. First, the regulation does not have a single textual reference to the right to privacy, so the link to the informational self-determination is lost. Second, the regulation contains broad exceptions and restrictions from the general principles of data protection, including lawfulness and fairness. But most importantly, the requirement of consent is applied more narrowly. The consent rule is losing its significance in comparison to the directive, because the draft regulation applies strict requirements to its quality, such as the controller bears the burden of proof of the existence and validity of the consent, and the data subject has the possibility to withdraw his consent. Simultaneously, consent cannot serve as a ground for lawful processing where there is a significant imbalance between the data subject and the controller, which describes almost any relationship between an organization and an individual. Making consent more difficult to rely on, regulation, in fact, creates an incentive to seek other, more reliable grounds for processing, such as the legitimate interest of the controller. The irony of the situation, however, is that the data subject has a significantly less degree of control over data processing as a result. The following slides will demonstrate how. The newly introduced right to be forgotten is an excellent illustration of the degree to which a data subject will not be able to control collection and further processing of data. In case data is being processed on the grounds of consent, data subject has an unconditional right of erasure, and when legitimate interest is used as a ground for processing, an individual merely has a right to object and prove to the controller that his personal circumstances are more important than the business interests of the controller. So, when the proposed regulation is praised for the strengthening of enforcement of data protection standards, such as principle of accountability and more powerful supervisory authorities, one has to realize that those are not the substantive standards of informational self-determination. but the rules of fair information use largely determined by the data controller himself. In fact, the one determining what the legitimate interest of a controller is, whether this is business or the European Commission, draws the border of the future European right to data protection. Besides the point of comparison of the European and Indian data protection frameworks, this shift in the default rules of data protection may become a model of moderate relevance for India and become applicable on its territory. This Europeanization of transnational data protection regimes is a result of a general European prohibition to transfer European data to non-European countries unless they provide so-called adequate level of protection. Adequate, in essence, means comparable to the European. There are two approaches to determine adequacy. One is on a country-by-country basis. Its criticism is well known and I will not focus on it any further. And the second approach is company-based. Article 26 of the directive allows the transfer if the controller guarantees adequate protection of European data. Binding corporate rules are one of the most innovative ways to guarantee adequacy. BCRs is a set of binding processing rules that apply within the same corporate group and guarantee rights of data subjects after transfer, allowing data transfers across European borders among corporate entities within the same group. There are at least three ways in which the BCRs can transpose European shift in default entitlements into a legal system of a third country such as India. Firstly, it is a co-regulatory instrument that transposes the European data protection norms outside the European borders, including the potential shift. Second, the BCRs often govern data processing policies and architecture within the entire corporate group without distinction being made between European and non-European data. And finally, BCRs as a form of self-regulation are often used by corporations to cope with the inherent uncertainties of transnational data processing. Transnational data processing is inherently uncertain for at least two reasons. First, it involves new technological developments such as cloud computing, which were never dealt with before. And second, it involves unfamiliar legal systems. The one who frames the BCRs in this context determines the entitlements and scope of data protection rights within the corporate group with a possible spillover effect to the countries of operation.
The two panelists on the panel, please. After our remaining two panelists speak, we'll be joined by Aradhya Setia and Sarthak Gupta, who are both first-year students of the National Law School, who will talk about, who will propose alternatives to the adequacy argument in the India-EU data protection debate.
And Mr. Prashant Iyengar.
The other way around. You should make your panelists in blue flowers.
Good afternoon. I think most of what I'm going to talk about has been covered in some form or the other yesterday and today. So I won't go into a lot of details about the specific regulations in the EU and India. What we're trying to do is have a discussion on the comparative analysis of the two regimes.
Jindal, if you don't mind, I think you can stand a little.
Sorry.
You are hidden behind the desk.
Yeah, so the main topics that we'll be discussing on EU and Indian data protection law is the basic legal regime in both the jurisdictions, the kinds of data that are protected, the all-important concept of consent, registration requirements, the formalities, what exactly is done to protect data in these two jurisdictions, the transfer of data, and enforcement proceedings. Going to the legal regime, in India, I think we've already discussed that for the longest time, we did not really have a data protection regime. What we had was a constitutional remedy, and that was for violation of privacy by the state, and it wasn't really effective for personal disputes between two individuals. We do have the law of torts in India where you can get damages for, say, maybe interference, breach of confidence, etc. But again, damages are still at a very nascent stage in India. The courts are wary of awarding high damages, and it's not really certain whether the law of torts can prove to be a very effective remedy. We have the Personal Data Protection Bill, which was introduced a few years back, but it's still not seen the light of day. Now, in the absence of a specific legal regime, what we have today is sort of a stopgap arrangement where we have data protection regulations enacted under the Information Technology Act, which has helped to bridge the gap to a certain extent, but because it's under the Information Technology Act in itself, it has some restrictions, which we'll discuss. In the EU, as we've all discussed, it is the golden standard of data protection in the world, and the EU has a lot of directives dealing with data protection. We won't go into each of them separately, but what we're going to try and do is see how some of these directives play with the Indian regulations and what is the effect. Moving on to the types of data that is protected. In India, there are basically two buckets. One is a very big bucket and one is a smaller bucket, to put it very simply. We have personal data in India, which is defined to mean any data which is capable of identifying an individual. So it could be your name, your address, your telephone number, your dental records, anything. And the funny part, or rather the strange part rather, is that there is no compliance which is mandated under Indian law of protection of personal data, but there is a liability attached. So the law says that when two parties enter into a contract and personal data is exchanged, and there is a breach of contract as a result of which this data is disclosed, then there is criminal liability which is attached to this action. I think it's imprisonment of 3 years and fine of about 5 lakh rupees. So, and then coming to the second category of data, which is your more specific data, it's called sensitive personal data and information, or SPDI. I think we all know by now what it really consists of. It consists of information which is, it consists of personal information which can identify a natural person consisting of these items. Now, here what is prescribed under the law is a whole set of compliances which need to be followed by any entity that collects SPDI, and the liability is not, it's not prescribed for not following the compliances, but the liability is prescribed when an entity is negligent in protecting the information, and we'll discuss what that means in a short while. Another interesting thing in Indian law that we briefly discussed earlier is that the protection that is accorded to sensitive information is only accorded when it is in electronic format. So there's a whole world, I think Anay had raised this very pertinent question earlier. There's a whole world of information out there that is on paper, that is not in electronic format. Until today, we do not have a law that deals with that really. At least we do not have a statute that deals with that. However, when you're talking about personal data, which is your wider bucket, there you do not have this electronic format restriction. So by interpretation, the law would even apply to data, to personal data that is in non-electronic format. The applicability of the data protection regime in India is for any data, not necessarily restricted to data of Indians, but it applies when the collection, the processing, the storage, the transfer is happening in India. There are some exceptions as to what is not SPDI, and that's information that is freely available, information that you get under the Right to Information Act. Now, moving on to EU. In EU also you have two categories of data. One is personal data and the other is a special category of data. Personal data, similar to Indian jurisdiction, is data that can identify or that is capable of identifying a person, and its certain factors have to be kept in mind, such as physical, physiological, mental, economic, cultural or social identity. Now, the second category that is prescribed in EU special categories of data which are more sensitive. So it's any personal data that reveals your your race or your ethnic origin, political opinions, religious, philosophical beliefs, etc. Now, the point to be noted here is that while EU prescribes say more advanced compliances or more advanced methods for the protection of special categories of data, they also have some compliances which need to be followed for personal data. Not so in India. In India, our whole law right now is geared towards the sensitive information and not towards the bigger bucket of personal information. And one point here to be noted, and this is something that from experience a lot of our European clients get very surprised, is that we do not have any law today in India which protects, say, your racial origin, ethnic origin, political opinions, etc. Because our SPDI is only limited to financial information, health information, etc. With respect to liability in the EU, liability arises for damage as a result of unlawful processing operations. And my understanding is that the liability is usually in the form of compensation that is paid to the aggrieved person. I do not believe there is a criminal sanction that's involved in breach of data protection. In the UK Data Protection Act, it is said that when a breach is accompanied by violence, say when an officer has been assaulted when someone trying to get access to data, then you'll have criminal liability, but that has nothing to do with data protection as such. In India, we just discussed when it comes to personal data, criminal sanction is involved. The applicability of the EU directives is towards establishments that process personal data in their premises. And the medium that it applies to is that it applies to automated data and also applies to data which is structured so as to form a filing system. So even manual data, even your paper data is included within the directives. It's a very important distinction because in India today, as we've been discussing, it's only digital data that gets protection. There are some exceptions in the EU as well, where processing is done in personal capacity or processing of data is done for security reasons. It doesn't attract the compliances or the liabilities. Coming to consent. In India, for collection or processing of personal data, which is again that bigger bucket which includes any information, there's no specific consent requirement because the premise is that it's being collected under a contractual arrangement, but no specific consent is required from the data subjects as such. However, when you're collecting any sort of SPDI from a natural person, then consent has to be taken, and there is no exception that is provided. Even if it's taken for some public reason or anything at all, consent has to be taken. When the law was drafted, it said written consent has to be taken. Now that seemed to defeat the whole purpose that you're talking about an IT Act and you're talking about written consent. So the government was quick to clarify that this consent includes electronic consent, so all the I accepts and the click-through mechanisms also work. India has a specific opt-out provision. So a person who has provided consent can withdraw the consent or can choose not to provide the consent in the first place. And the only remedy that is then available is that the data controller can cease providing the services for which the information was being collected. So if you're visiting some e-commerce site and you want to purchase something and you need to give your credit card information, which is SPDI, and you refuse to do so, the e-commerce site will not